This policy brief aims to assess the impact of the armed conflict in Colombia on the environment and indigenous peoples, and the application of the rules of international humanitarian law and international criminal law on the armed conflict in Colombia, and implications for the special jurisdiction for peace, or CRAP, and international criminal justice.
So the armed conflict of Colombia has been going on for a long time. Particularly in the last 5 years, we saw a new constellation of actors coming in and actually trying to seize access to land, access over resources, trying to benefit from the void that was left behind by the FARC and that the government is not able to fill. So in that situation, we see a lot of violence, particularly in indigenous and Afro-descendant communities, forced displacements, environmental degradation in many parts of the country taking place. And very concerning over the past years is the increasing threat that is being done to environmental defenders, social leaders, community leaders, indigenous rights defenders in Colombia who are increasingly targeted, threatened with violence, but also killed, which is quite complex, and it makes the situation of peace building in Colombia quite complex as well.
So yes and no. There are only a few rules under international humanitarian law that specifically protect the environment as such, and these are not applicable during the internal armed conflicts such as the one in Colombia. And this means that the environmental protection could be lawfully lowered during an armed conflict. There are specific obligation, for instance, under the Anti-Personal Mine Ban Convention that says that state parties must remove landmines as soon as possible after an armed conflict, and Colombia is a party to this convention and would be under such obligation. There are also rules in environmental law and human rights law that would apply and that would actually also contribute to the environmental protection, and these continue to apply during armed conflict. But if these rules would collide with the rules of international humanitarian law, they will have to stand back because international humanitarian law prevails during armed conflict.
So, in answer to your question, the ICC, or the International Criminal Court, currently doesn't have jurisdiction over ecocide. It does have jurisdiction over crimes against humanity, genocide, the crime of aggression, and war crimes. When conceptualizing ecocide, there has been attempts in the 1960s to have an ecocide convention, but ultimately no concrete measures or treaties were adopted on the crime of ecocide. Currently, there is an international campaign to establish an international crime of ecocide.
The background of considering the environment as a victim of the internal conflict, it comes from a request in case 02 from an indigenous community, the Awa people, that petitioned for the JEP to acknowledge and accredit their territory as a victim, as it has identity and integrity, and it should be made subject of rights. And by granting this request, JEP actually did break some new land. It's quite a new thing to acknowledge the environment as a victim of an armed conflict. This is probably the first time a court has done something like this.
I think it's important to consider that Colombia right now is at a crossroad. I mean, if the environment is considered the victim of the armed conflict that happened in the past, this is really important, but we shouldn't forget that right now the environment is facing severe degradation during the post-conflict period. Since the peace agreement was signed, deforestation has increased tremendously. There's an increasing onslaught of mining, legal and illegal mining in Colombia, new development projects, road expansion, illegal and legal land grabbing going on. So if the environment was a victim of the armed conflict, it could also be seen potentially like actually a victim of the post-conflict or of the peace-building activities that are going on in Colombia.